Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having been before this court are admonished to draw nigh, give their attention to the court. Now sitting.
Please be seated. Good morning. We welcome all of you to the Kansas Supreme Court, including those who may be watching on our live stream. We will hear two cases in the first portion of our docket today, take a recess and then continue. We'll make note that we do have an empty chair today due to the impending resignation of Justice Wilson from the court. She will not be participating in these cases. Not only is she not present for the arguments, but she will not be participating in the decision-making of the cases either. So the court has received the briefs and of the parties, as well as the record and any decision from other courts that we are reviewing. We have looked at those and have those made notes for ourselves and otherwise familiarized ourselves. So there will be times we're looking at our computers as we compare things that are being said with our own notes or with the briefing or with the wording perhaps of a statute or of a decision that has been made. Various reasons that we will be doing that. Please know that when we do that, we're not distracted. We are actively listening, but looking at something that is helping us to assimilate the information that we're getting from the attorneys. With that, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
Thank you, Your Honor. May it please the court. The first case on the 9 a.m. docket for Tuesday, May 13th, 2025 is appeal number 127414 in the matter of D.J. Sedgwick County, briefs both sides.
May it please the court. The appellant DJ appears via Caitlin M. Dixon of Wichita, Kansas, present and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 126279, State of Kansas versus Devontae Jamal Brown, Johnson County, briefs both sides.
May it please the court, I'm Ryan Ettinger, appearing on behalf of the appellant Devontae Brown, present and ready for argument.
May it please the court, Assistant District Attorney Daniel Obermeyer on behalf of State of Kansas FLE, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
All right, thank you, Mr. Shima. We'll now ask counsel in 127414 in the matter of DJ to please come forward.
May it please the court. The appellant DJ appears by Caitlin M. Dixon. Madam Chief Justice, may I reserve 3 minutes for rebuttal?
3 minutes is granted. Thank you.
Thank you. On December 8th, 2017, DJ entered a plea under the EJJP statute. He pled no contest to first-degree felony murder, attempted aggravated robbery, and possession of marijuana. These charges and convictions arose from a botched drug deal that occurred when he was just 15 years old. Regarding this drug deal, pursuant to law enforcement's investigation, they interviewed DJ. He voluntarily told law enforcement that he had gone to the scene to purchase marijuana. He stated that at the time he was unarmed and was accompanied by 2 adult men who were 24 and 33 years of age. According to DJ, it was one of those adults, not him, who suggested robbing the individuals they were meeting. And then when the transaction unraveled, DJ was tackled, a struggle ensued, and one of the adults fired a single shot that killed another 15-year-old who was also part of the drug deal. He fled the scene, but later cooperated with police when he was interviewed, and he identified the adults involved and provided an account of what happened.
Those facts were part of the factual basis for the plea that you just recited. The state seems to allude in their brief that it was your client who was responsible for the shooting.
There's information, I believe, in the probable cause affidavit that says my client shot the individual,
Right.
but he stated, and that's also in the affidavit, that it was the adult that shot the individual.
Yeah, and I don't know that matters. I just wanted to clarify.
Yes, but he maintains it was one of the other adults. At sentencing, there was a plea pursuant to EJJP. The state had initially filed a motion to prosecute as an adult. That motion was later amended pursuant to the plea, and DJ did not object to the motion being granted for the EJJP case. Pursuant to his plea, the juvenile sentence, he was sentenced to a correctional facility until he was 22 and a half years of age, and then was supposed to have aftercare until he was 23 years old. He also received the stayed adult sentence at that time, which was 25 years to life. Following his release from the JCF, he was placed on supervision with his supervision officer. According to his supervision officer's testimony during the motion to revoke his juvenile sentence hearing, he consistently passed his drug tests. He maintained regular contact with the supervision officer, and he held full-time employment. Despite this, the state moved to revoke his juvenile sentence. They filed an original motion with one minor incident that occurred, and then they later filed an amended motion that dealt with a second minor incident that occurred. During the motions hearing, I think it's important to note that his supervision officer, when
You describe it as a minor incident that occurred?
yes, there were two incidents. The first one was from December.
Your characterization of minor being in a car that contains marijuana and 3 weapons, and he's in at the least in constructive possession of, you consider those minor incidents?
Well, he was never, for one of the incidents, he was never formally charged for it. And I would argue that with the incident involving the car with the several other individuals and also the suspected marijuana, one of the individuals in the car stated that some of the marijuana was hers, that was in her purse. And I believe she also stated that 2 of the guns were hers. So really, there could possibly be a constructive possession argument, but at the same time, I think there could possibly be an argument that if it had ever gone to preliminary hearing, that I don't know if a court would have found there was probable cause that he was a felon in possession of a firearm, and the possession of marijuana, I believed, would have been just a misdemeanor. So it would have been a Class B non-person misdemeanor at the time.
There was oxy in the car too.
There was, and I believe that may have been in her purse as well. And so I would argue that if she said it was hers, then I don't think there would have been any probable cause.
Where were the guns found?
If you could give
In
me
her purse?
what I believe,
I think they were under the seat, weren't they?
Weren't they under the seat he was in?
yes,
That he
So
was,
they were under the seat he was in.
not all of the guns.
Right, but
Right. Right. But it wasn't his car that he didn't own the vehicle.
okay, but when push comes to shove, okay,
Mhm.
let's look at that. You know, you could say you could say that it's not, that it wasn't charged. But that's not what the conditions say. The conditions say obey all laws, right?
Yes.
Okay, and then we have that, and then we do have another incident where, your client gets pulled over and there's marijuana coming from the open door. They found rolling papers and they found weed or marijuana from the look of it. So based on these two, whether or not they're charged or not, would you say that the statute requires the court to, it says the court shall revoke if it committed a new offense or violated one or more conditions of the juvenile sentence, the court shall revoke the juvenile sentence and order imposition of the adult sentence, or upon agreement of the district attorney and the attorney of record, modify the adult sentence. But even though there's that in there about modifying the adult sentence, would you say that does the trial court have discretion?
Absolutely not without the agreement of the prosecutor.
Revoking the juvenile sentence.
I'm sorry, the court has no discretion to revoke the juvenile sentence, but when it comes to modifying the juvenile sentence, the prosecutor has to be in agreement with the defense.
Okay, so, but your argument is that there's not substantial competent evidence to support?
That's one of my arguments. My first argument deals with the constitutionality of the statute itself that gives the court no discretion when it finds a violation of the juvenile sentence.
And then there's substantial competent evidence, and then the adult sentence. Did you try to talk to the prosecutor about getting a lower? I don't know if you were the counsel below.
I was not, Your Honor, but it was actually in the transcript. The attorney of record for the district court did try to talk to the prosecutor. The district court attorney was Robert Moody. The prosecutor was Nicholas Means. And I believe Mr. Means was actually the prosecutor throughout the entire case. The appellants had a different attorney for his plea, and he had a subsequent attorney for the motion to revoke. And in the transcript, Mr. Moody says, I tried to talk to the prosecutor for, I believe, over a year, because the motion to revoke was pending for a year, and the prosecution refused to come to any sort of agreement about modifying the sentence.
Okay, so under the statute, since there wasn't an agreement, the adult sentence is imposed, correct?
Correct.
Under the statute. So, well, I guess this is pro se issue, the first issue. Did the district court err in holding that the statute requires the district court to impose the adult sentence? So you would say, I guess contrary to your client, that you have to.
Correct.
Okay. Thank you.
And getting into that, what Justice Standridge was saying, that's the fact that the district court, when they find that there's been a violation of the juvenile sentence by preponderance of the evidence, the district court has zero say as to whether or not they can modify that sentence, unless the prosecutor and the defense come to an agreement. And I believe that that's the biggest part of this case is you have, instead of the court, which is a neutral, objective body making that decision, you essentially have the prosecutor who, for any number of reasons, whether it's political reasons, maybe their boss is running for DA or CA again and doesn't want to appear that they're soft on crime. So, or maybe that prosecutor that was on the case the entire time.
What exactly is your constitutional argument? And let's kind of set the framework
Right.
here. You didn't raise this at the district court. Not you, but it was
Correct.
not raised at district court.
Correct.
It's being the first brought on appeal. Typically, we don't allow an as-applied kind of challenge first time on appeal because it takes facts. And
Correct.
what I'm can't see is you're then raising an as-applied challenge, but you then rely on specific facts of your client's situation. You're relying on the hard 25. You're relying, which is not always disproportionate. You would agree, I would think, or is a hard 25 always disproportionate?
I think in this matter it was.
In this matter.
Yes, but
So that gets down to facts, specifics matters in this case, not in every case. And so how is that not an as-applied challenge?
I believe, Your Honor, that even in our United States Supreme Court cases like Miller, Montgomery, they talked about the facts of the defendants or of the juveniles.
Miller was a life sentence without parole.
Right.
That makes sense to me because that
Right.
applies to every juvenile in that situation. This does not.
It is not technically a hard 50 or anything like that, but at the same time, I understand what you're saying, but it's a categorical challenge. But you can to just disregard the facts when they can be used to support a categorical challenge is essentially what I'm saying, Your Honor, is that our United States Supreme Court has looked at the facts and stated, yes, these facts do matter. And those facts can be used to show why a categorical challenge can be supported.
Well, how is a lack of discretion? That's what you're arguing here is the district court had no discretion. I think that's one of your arguments.
Mm-hmm.
How is that disproportionate to an offense? It doesn't square. It doesn't fit. I can't see where it does.
I'm not sure that I understand your question.
Well, you're arguing that the district court lacked discretion to be able to impose a different sentence other than what was imposed during the process, the hard 25.
Right.
Is that right?
Yes, but I argue that the court should always have discretion in this type of matter to be able to impose a sentence, because if the prosecution had agreed to it, then the court would have had the discretion to modify the sentence. And I don't believe that the prosecutor should be the gateholder of whether a judge that's familiar with the case should be able to modify a sentence in this type of case.
But what makes that unconstitutional, though? I understand a policy rationale for that, but what's the constitutional basis of that argument?
It's Eighth Amendment cruel and unusual punishment is what I'm arguing for this case, Your Honor.
Because the sentencing judge lacks discretion to modify? That's
In part, yes, but that in this, when you look at this case, and when you look at the violations in this case, or the alleged violations in this case, I would argue they are relatively minor, and that the imposition of a 25-year to life sentence for possibly having some suspected marijuana and possibly being around other felons is not proportionate to the sentence that he got.
How is that issue preserved on appeal? As I look at everything, you didn't raise this until your reply brief. How does that conform to Rule 6.02?
I believe it conforms to 6.02 because I didn't just incidentally raise it in my first brief. I supported everything with my I think there's 5 or 6 pages in my brief where I talk about the categorical challenge.
Which brief? The first brief?
The first brief, yes.
Just back to your proportionality challenge, it's just seemed to me you were arguing that we ought to weigh the hard 25 against the facts that led to the revocation. Don't we weigh it against the initial crime?
Yes, the initial crime.
It's not, the question isn't, well, it is the fact that maybe he had some marijuana proportional to 25 years. That's not the question, right?
Correct.
There are other questions? All right, thank you. Mr. Gillette?
Thank you, Your Honors. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I want to start out with what I believe this court has heard from the podium this morning is exactly what the state has asserted in its brief, that this entire appeal is all about arguing about facts. There is absolutely no question that the defendant respondent here violated his EJJP sentence after he received that substantial benefit for being involved in, and the state believes the primary ringleader, despite only being 15, in a drug deal that resulted in the homicide of another 15-year-old in Wichita. The state, given the fact that there, as the state points out in its brief, some of the allegations for defendant's violation are not a violation of that EJJP sentence, are not even disputed here. And I do think it is important to keep in mind that EJJP in and of itself is a somewhat rare and unusual tool that is employed in somewhat rare circumstances, but its application is always fact specific to the individual offender and the crime that they have committed. And so the state believes from the get-go, there is absolutely no way that this court can reach the constitutional claims that have been pressed here today.
Let me ask a question.
Sure.
So if DJ had not been tried as, or, under the juvenile code, and he had been charged as an adult, would the court have had, in felony murder, have had discretion to depart from a hard 25?
Candidly, I don't know. I don't know that it would have. Again, that's one of those things that's a factual question as well. Even if it had, it would have been a factual question.
Right. No, I'm just asking about discretion.
And candidly, I'm not certain as I stand here today.
Well, I mean, a motion for departure?
Sure. I mean, it's
And,
possible.
and the court would have discretion. You know, no matter what the facts are, the court, even if it was denied, the court would have the discretion, right?
Again, Your Honor, I apologize. I'm not certain. I know that as I understood it, the mandatory sentence is the hard 25. There may be some isolated circumstance where a departure is at least in theory possible, but I'm not sure that exists.
Would you say that that's a matter of law, though? I mean, we research that and determine
Yes.
whether the judge has discretion.
Yes.
So isn't the constitutional claim here not fact-based at all? It's just saying, look, if I would have been charged as an adult, even, you know, I mean, even if you compare yourself proportionality, you know, to an adult with the same charge of felony murder, okay, that the judge would have the opportunity to, if that's the law, grant a motion for dispositional departure. And but because he was charged first under EJJP, now he doesn't. And though, regardless of any fact that the statute then is unconstitutional, because minors who are charged under EJJP don't have that opportunity.
Respectfully, Your Honor, no. And I believe it's because, as the premise to your question actually began, if I heard you correctly, with a comparison of juveniles to adults. That is not strictly a categorical comparison in every circumstance. It would not be in the circumstance of an EJJP. And I do want to make it clear that—
Well, let's not compare them. Let's just say it's cruel and unusual punishment.
I'm
You know,
not aware—
for,
Sorry.
you know, I mean, under that category.
I'm not aware of any authority to support that position. This court's own authority in the case of Brown that I cite in my brief has said that a hard 20 mandatory applied to juveniles that commit murder isn't cruel and unusual. There's simply no authority to support this being cruel and unusual at all.
But that's not the issue, whether the hard 25 is cruel and unusual.
That's the issue that the defendant seems to want.
The issue is the no
press.
discretion.
But that is, I guess that is how we're going to look at it today. But again, before we even get to that point, the amount of discretion involved is immense. The state filed this case in juvenile court. They also filed a motion for adult prosecution. The prosecutor, in its discretion, agreed to enter an EJJP plea.
How does that, remind me, how does the EJJP process work? Is it something that is, it's kind of a discussion and an agreement with defense and the state, or does the juvenile move to be prosecuted under a EJJP, or is it the state? How does it work?
The state would move to prosecute someone under EJJP, and then KSA 382347D requires a consideration by the court of a laundry list of fact-specific questions regarding this specific juvenile to determine whether or not they qualify for an EJJP sentence. And then similarly, in any instance of a revocation, there would be a factual consideration of whether or not the state proved that. Then there's again the prosecutor's discretion to discuss with the defense and see if there's any possible way that we could come to an agreement to have the court exercise additional discretion. There are fact-driven questions and discretion exercised throughout this process because it is such a unique statutory provision. And as I argue in my brief, in fact, the state believes that the EJJP statute gives the district court immense discretion on the front end. And I think that might weigh towards Justice Standards, your question. Before even authorizing the potential for an EJJP sentence, the district court must exercise an immense amount of discretion in weighing that laundry list of factual matters as it regards a particular juvenile offender. So I think that discretion is still there. And of course, the defendant can try to avoid an EJJP prosecution, but here the defendant invited it. He wanted to be—
Well, right, because the state filed a motion to bring the charges as an adult.
Sure.
And the court denied that.
No, it didn't. The state withdrew it based on an agreement that the defendant wished to be treated as an EJJP offender.
Well, because that motion was pending. I mean, who wouldn't?
a lot of people might not, especially if they thought that they had a strong case. Why would they not try to fight it all the way, fight the map? Then they would have to be treated as a juvenile offender, and then they would be subject to all of the reductions in sentences that are applied to juveniles. There's every opportunity for them to have fought.
So you started your argument by saying we can't reach the constitutional issues because there's unknown facts.
Correct.
And I am also struggling with what potential unknown facts are there that prevent us from reaching the constitutional.
I'm gonna address the two claims separately, if I could, Your Honor. First, in regards to the categorical, what I heard the defense argue today again was a lot of undisputed facts, but also a part of that, as the state points out in its brief, that issue isn't even properly raised before this court. And as Justice Biles asked during their argument under 6.0285, it was way too late to try to preserve any kind of a categorical challenge. And furthermore, I would suggest that a categorical challenge, as the state points out in its brief, one of the very first questions is, well,
Didn't we in State v. Gully address the categorical Eighth Amendment challenge for the first time in appeal because of a question of law that requires no new fact finding?
I know I cite Goley in my brief because I have it here in my notes, but candidly, as I stand here today, I believe that they may have, but I am not certain about that. What I would say is that the state maintains, as we argued in our brief, that trying to evaluate this, for instance, exercising the court's independent judgment, and candidly, I don't know that the state resisted. And if I'm recalling correctly, the state did not resist consideration of that issue for the first time there. And I'm not certain why, because part of the analysis would be this court's independent judgment of the 7 or 8 factors that are required in order for a categorical violation to be established. And those definitely do require some factual analysis, at least in some degree. At least that's how the defendant presents it here as well. But if this court were to conduct that kind of a categorical analysis here, even as a matter of law, the defense brief notes 4 states with similar or harsher sentences, and I cited in mine 18 states plus the District of Columbia, 16 of which provide for sentences almost just like this.
But what about the discretion? All of those take any discretion away from the judge?
Some allow for limited discretion, others do not.
But isn't that the issue here, the discretion?
To be candid, I don't know for sure. Just because of the way that this was briefed, I cannot say for sure that was. As I heard the argument this morning, that seems to be a little bit more of the question. But actually, it seemed like the categorical.
Perhaps it was something that was actually raised by the defendant pro se, because the first issue raised by the defendant pro se was, oh, well, no, and his issue A and B, he says, did the district court err in holding the statute requires the court to impose?
The pro se, though, was relying on prior case law, not the amended statute that does not allow for discretion.
I would concur with that. The defendant sought and has sought all along to return to in re AMMH, which has been legislatively overruled by the statutory amendments.
Right, but the issue was raised, whether it was under the old statute or not.
Respectfully, I would disagree, because that statute at issue there was not in play here at all.
And sorry, go ahead. I didn't want to interrupt you.
Finish with Justice Stiegel, your question, the last part of your question. An as applied challenge is always factually specific.
Well, it could be, but the way it's presented here, it's argued on, at least, let me rephrase my question. Why couldn't we simply assume all of the facts that are alleged by the defendant in his as applied challenge to be true? If all those facts were true and his constitutional challenge still failed, would we be able to reach the issue?
I'm going to answer your question in two ways. The first thing I would say is if you're having to assume something, that's not a fact. And then second, if you can assume that everything that the defendant says is true and he still loses, so be it.
Well, that's why I'm asking the question, because this is tied up with an ineffectual assistance claim.
It might be.
And it seems to me that while you argue against us being able to hear the claim, you maybe inadvertently make an argument in favor of a Van Cleve remand.
As I argue in my brief, we are too late for a Van Cleve remand. The defendant does maintain the opportunity to try to pursue relief under 60-1507 or from our federal courts in a 1983 action, as I know. But those, again, will require very fact-driven analysis, and that is an analysis that has to be conducted at the district court. That's why Van Cleve exists. There are facts that will drive that. There may have even been conversations between the defendant and his defense counsel. We simply don't know. As was noted earlier, there was nearly a year.
You would prefer a remand and a hashing out of all that at the lower court rather than simply us taking the argument at face value. And I'm not suggesting the court would decide this, but if the court were to decide that's not enough, you're still insisting we can't do that.
The state maintains that this court cannot conduct the necessary analysis here. I do not prefer a remand for a Van Cleve type hearing. I think that would it would far exceed the scope of Van Cleve because it's never been requested in this case. Again, so it would be abandoned under this court's jurisprudence. The state's suggestion is that if the defendant wants to try to make some kind of a meritorious claim in regards to his counsel, the proper place to do it for the first time is in the district court. That's all I'm saying.
So it seems like the biggest issue, that factual issue, is whether DJ was the ringleader or was just the 15-year-old following along with two adults. But if we would assume, for purposes of Justice Steagall's exercise, perhaps if I can say it that way, that he was the innocent, just going along with the, under the persuasion of the two adults following their lead. And we could determine under that this was not, a hard 25 did not violate the 8th Amendment. You don't want us to rule that one. Just to put it to kind of put a case specific twist to the question.
Respectfully, yes. The state is of the position that the way that these claims have been made here is inappropriate. It's inappropriate for this court to reach them under any circumstance in this case.
Well,
is it your belief that what we need to focus on is the original sentence as opposed to the revocation?
I believe that is correct. I think that this court would have to actually consider both. I think there's obviously some primary focus on the initial offense because that's what triggers the imposition of an underlying sentence. There's obviously then the question of, well, how would we get away from that? And then that is a question of fact for what can be demonstrated as far as the violation. So I think the primary focus does have to be the underlying offense.
If I may, I'll just try my question perhaps from a slightly different angle.
Okay.
Because what I'm thinking about are kind of these ineffective assistance types claims, which always require some showing of prejudice as well. So I guess one way to reframe the question is, in your view, is there any universe of potential facts in this case which gets the defendant relief? And if the answer is no, then it seems to me that there cannot be a showing of prejudice of any kind.
My answer is no.
And why aren't you arguing that to us, I guess?
Because procedure matters. And I think that the statutory provisions that are at play here matter. This court's precedent and how these claims have to be raised and litigated matters. And that's what the state is asking this court to follow once more. Okay. if there are no further questions, I appreciate the court's time. I'd simply ask that the district court's ruling here, finding defendant respondent in violation and imposing his underlying sentence to be upheld. Thank you.
Ms. Dixon, you reserve 3 minutes.
Thank you. I believe the prosecution mentioned the Brown case, and I want to specify that that is a different set of circumstances than in this case. The Brown case, the juvenile was directly prosecuted and sentenced as an adult. It was not an EJJP case, and they had the motion to prosecute as an adult hearing. And the court found to prosecute that this person as an adult, whereas here the EJJP was pursuant to a plea agreement. Unless there's any other questions, I would rest my brief.
Your categorical proportionate is a proportionality challenge, right?
Yes.
And I guess I'm getting back to my question earlier is, how is lack of discretion disproportionate?
I think that a lack of discretion is disproportionate because there's no discretion as to what the sentence could be. The court has no choice but to revoke the juvenile sentence and impose the adult sentence if it finds by preponderance of the evidence that the juvenile sentence was violated. Now, the only time you could say that there was discretion is from the prosecutor. And I think that could be a separation of powers argument too, and that it shouldn't be the prosecutor for whatever reason to decide as to whether or not the court can modify a sentence.
Are you asking for a Van Cleef? You never have.
I did not ask for a Van Cleef in this, Your Honor, because it still, even if we had done that, it still doesn't deal with the statute. If we had a Van Cleef hearing and even if the defendant, or excuse me, the juvenile had won, and then we go back and have another motion to revoke hearing, and the court still has no jurisdiction to modify the sentence, then we're still here. And I essentially thought that, this is only going to delay. It's only going to delay what my client wants.
I'm confused. Am I misunderstanding your ineffectiveness argument then, or claim?
Could you clarify?
Well, are you asserting that trial counsel was ineffective?
Yes.
And how do you get there?
Because he didn't bring up he did not satisfy the record to keep the case specific argument.
But how do you win on that claim without some, I guess I'm curious how can you win on that claim without a remand, I guess?
Because this court can still make a ruling that under a categorical challenge under the 8th Amendment, that this is unconstitutional, that the statute is unconstitutional.
Okay, so you're limiting your ineffectiveness claim to the categorical argument as opposed to the case specific argument.
Yes.
Okay.
Is that right?
I didn't understand. That's what I didn't understand.
In deficient performance, there isn't a world where there might have been a fact question about pursuing a categorical challenge. I mean, I think the argument would make sense that if it's there, it should be asserted, but it's sort of this unknown as to what the motivation of counsel was.
Correct. I don't know what his motivation was. I think the only mention of any constitutional argument, if you can even call it that in the transcript, was he said something along the lines that there's constitutional issues with this sentence.
Would you agree that if this court reached your categorical claim and ruled against you, that would essentially require us to also rule against you on your ineffectiveness claim?
And I don't think so, because
well, why not? If your ineffectiveness claim is limited to the failure to raise the categorical constitutional argument, and then we rule against the categorical.
I'm sorry. I apologize. I believe that the trial counsel didn't make a specific record that would have allowed me to brief the case specific.
Okay, so but
Yes,
that goes back, okay.
yes.
So that helps clarify.
Okay, I'm sorry.
And I guess that goes back to my original question, which is how can we ever get to your ineffectiveness claim with respect to the case specific argument without a remand? And you're not asking for a remand.
I'm not sure.
Okay.
Other questions? Thank you, counsel. Thank you to both counsel for your arguments today. The court will now take this matter under advisement. What I mean by that is that later today, we will begin discussions about the resolution of this case. And at that point, one of the justices will be assigned to write a draft opinion that will process will involve all of us reviewing those opinions. It may involve others writing separate opinions that will ultimately result in a decision of the court that will be filed with the clerk of the appellate court. When that filing occurs, there's a press release that we have released it. It is also posted on our website, so you're able to read the entire opinion at that point. With that, thank you, counsel. We'll now ask counsel in 126-279, the state of Kansas versus Devontae Jamal Brown. Please come forward.
Good morning, may it please the court. I'm Ryan Edgar, Assistant Appellate Defender, appearing on behalf of the appellant Devontae Brown. With the court's permission, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is reserved.
Thank you, Your Honor. Johnson County jury convicted my client, Mr. Brown, of 1 count of felony murder with the predicate underlying felony being the distribution of marijuana, and a 2nd count of attempted 2nd-degree murder. The issue that I would really like to focus on this morning before the court is the first issue raised in our appellate brief. Of course, if the court has questions regarding the remaining issues, I would be happy to address those as well. What we've argued in the first issue is that the evidence of distribution of marijuana was insufficient to support the conviction for felony murder. Broke that down into basically 3 components, and I can just go through those in order for the court. The first component is that we've argued that under the Kansas Criminal Code, the state was required to prove that the substance that my client possessed at the time that he arrived at the Johnson County Public Library that night to meet with the 2 buyers in this case was in fact, the illicit version of marijuana. And I arrived at that argument because there's evidence in the record that comes from the state's own eyewitness to this offense, the only person to be in the car with Mr. Brown that night. And he brought it up sort of, this was his testimony, that he didn't necessarily 100% believe that the marijuana Mr. Brown had was actually the kind of marijuana that he was looking to get his hands on in order to get high. As the court's well aware, there are forms now of cannabis that are not criminalized under the code. And my client was charged with possession under the statute that requires it to have that component of the Delta-9 tetrahydrocannabinoid. So I think that when that testimony is reviewed, no reasonable juror is going to hear from the person who was actually purchasing it, who stands up and testifies, I didn't really believe that this was necessarily the real deal. And I think if we zoom out from that and take a look at the entire global picture here, this was a situation where nobody that was involved in this supposed transaction was honest. They were all, this was all a ruse from both parties, I would argue. It looks like from, I guess, circumstantial evidence from my standpoint and my client would be that he never as soon as the money was shown in that car, he reached out and snatched it from him. He wasn't there to transfer marijuana. He was there to take.
Let me get to the basics here. Let's start with the statute. So 215705 says you cannot distribute or possess with intent to distribute marijuana. That's under A4, right?
Mhm.
Schedule 1, that's a Schedule 1 substance, marijuana. So in that statute, it just says marijuana, one word.
Right.
It doesn't say marijuana with THC. It doesn't, there's no THC or whatever that long word is that, yeah, that you did so great in doing. Okay. And then when we go to the definitions at 215701,
Mhm.
there is a definition of marijuana. It means all varieties of the plant cannabis, whether growing or not, the seeds, the resin, compound, all that stuff. Nowhere does it say it has to have THC, correct?
I thought in that description, there's those two statutes read together. I would say that it does have to have that Delta 9 tetracannabinol.
Why?
Well, because that's I think that because that's the active ingredient that is later when there's it's carved out an exception for not being illicit cannabis, then that's what's excluded.
Where does it say that in the statute? It says marijuana does not include the mature stalks of the plant, any Schedule 2, which is basically, well, I don't remember what that is, 2 through 5, okay?
Right.
Drug products approved by the FDA, CBD, or.
And I think that's where we're at is the CBD component, which.
So marijuana does not include CBD.
Right, which is what I was.
Would you have something that had CBD and THC?
I'm not sure. I think that in small quantities. All I know is that it cannot have THC above, I think, the CBD and the hemp provisions that are excluded. It's like 0.03%.
Right, but that's industrial hemp.
Right.
For commercial, it's under the commercial industrial hemp. I just don't see when you read these two statutes together, they don't even mention THC.
No, I don't think that they necessarily might mention THC.
And when you look at the cross-examination of the defendant here, I mean, that's what he said. They just focused on, well, did you, it didn't have the crystallized thing.
Right.
Something
He
about.
testified that
Yeah,
he didn't think he thought it was fake, essentially. It was not real marijuana.
Well, he didn't say that. I mean,
he said he did, and he said volume 81, page 87 didn't quite look like it. And there's testimony from 77 through 79. He testifies a couple of times and states that I didn't think the marijuana, I had belief that this wasn't real marijuana. Now, whether we want to dive into the actual, like what it, try to unravel what it is.
he said the real deal. And I mean, it was
The real
all
deal, right.
questions. He answered yes and no.
Yeah, he did say,
I
I
mean-
didn't think it quite looked like it. He also said it didn't, like he said, it didn't look crystally. So be that as it may, he's testifying that whatever he's being presented with, he didn't think was actually marijuana. So that's the crux of my argument on the point of possession. Even if the court disagrees that in fact he did have marijuana, my client did have marijuana, then we still have to get to the idea of whether he intended to distribute marijuana.
Okay, but just getting back to this marijuana. Okay, so although RB admitted he was not sure whether the substance was real marijuana containing THC.
Right.
Okay, that to them, that was real marijuana contains THC. That's what I got out of that
Can I
exchange.
clarify something with you, Honor?
I'm sorry?
When you say with them, according to them, do you mean the prospective buyers or my client?
Although RB admitted he was not
Okay.
sure.
Yeah, okay. The prospective buyer, he was
The
not sure.
prospective buyer, oh,
Right,
sorry,
right.
yeah.
No, I understand now.
Was real marijuana and agreed that it could have been fake. He testified that it looked like marijuana based on its appearance and smell. And the jury was left to weigh that conflicting evidence. And we look at the light in the most favorable to the state, right?
Correct.
So there was evidence.
There was some evidence.
And we can't reweigh this back and forth, you know.
And that's,
He said on direct.
That's honestly, that's fine. That's the first component of my argument. I really don't, I don't want to get this bogged down so much. And that's, I mean, I don't mean to like.
No, go right ahead. I thought that was the main gist of it.
No, the main gist of my argument really is just that there was no, even if it was marijuana, there's no intent to distribute here. And that I get to by the simple fact of, this was all a ruse. Even in the state's brief, it says that the party there, the two prospective buyers in this case admitted that it was a ruse. The state said it was a ruse. There was no intent to distribute marijuana here. The whole intent was to commit a robbery by both parties. And that's what's so puzzling about the outcome in this case.
And what would he have gotten from the robbery?
Marijuana. Well, I mean, what he thought was going to be marijuana. I mean, and that's the whole point of my argument is really, okay, first of all, there's a big question of whether it was marijuana at all. And that came from the person who was supposedly trying to buy it. But another huge component about this is the question of an intent to distribute. And what I've argued in the brief is that there's no intent to distribute here. The intent from the prospective buyers was not to distribute marijuana, it was to steal marijuana. And it was also to steal marijuana that they testified for their own personal use to smoke it.
But why isn't that an attempt to transfer, which the statute includes?
Well, under this court's precedent, but fair enough. And under this court's precedent in Mora, where two parties are going to purchase marijuana in order to smoke it themselves, that was held not to be distribution.
How much marijuana was there?
It was, I want to say 4 ounces between two people would have been the two prospective buyers in this cases.
4 ounce. Why was I thinking something about pounds?
No, it was a quarter pound. That's probably because pound, quarter pound, and you were thinking pounds. But what's that? 16 ounces, so 4 ounces. So that's between two people. And so the prospective buyers, at least under Mora, legally weren't going to distribute marijuana when aren't distributing marijuana. It's clear that my client wasn't distributing marijuana. He went also under a ruse. I'd say based on, I mean, it's hard to distill. There's no direct evidence of what his intent is, but I think we can see from what happened, what he was planning to do. So both parties are there not to distribute marijuana. None of them are being honest. They're there to both rob each other. And it's so, they're charging the alternative here. And it's really puzzling that the verdict came down in the way it did. Frankly, as I'm reading through this, I was expecting to be stuck in a possible merger situation. But the jury found that it was distribution. And there's no substantial evidence. There's just no evidence, sufficient evidence that this was distribution. It was a robbery.
Not his own statement that he went there to sell the marijuana. I mean, even if it was a
Whose
lie,
statement?
wasn't that what your client? Isn't that how your client described what was happening? Is that he was offering to sell? Or am I misreading something?
He was
I don't
purchasing.
think so.
Okay.
I'm sorry if I can check on that during rebuttal. But
Okay. No, I'm probably just misreading and getting the names. Sorry.
yeah. But that is the crux of my argument, that this isn't a distribution, and and furthermore, there's killing.
What is the statutory presumption for distribution of marijuana under the criminal code? It's in grams, so I don't know how to convert that.
I'm not sure. I'd have to look at what the
like 450, I think 450 grams.
450 grams. What is 28 times 4? I think it's somewhat under. I think it's just over a quarter pound. So I don't think we've gotten to the statutory presumption yet. And I don't think that was ever brought up in any way at trial either. Obviously, that is what happened here. And as far as any sort of distribution, even if the court finds it was distribution, that distribution had ended by the time the killing occurred. So the criminal offense was, if it was distribution, furthermore, it was over at the time the killing occurred, because my client took the money from the buyer, said, "Get out of my car before I shoot both of you." And that's at the point that the brother comes in and starts wailing on my client. And that's when the shooting occurred. I don't know if the court has any additional questions for me at this time, but I think that's pretty much summation of my first issue. Thank you.
Thank you. Mr. Obermeyer?
Madam Chief Justice, and may it please the court. I'll begin by just giving sort of an overview of the case, some of the facts, because I think there's some confusion as to who did what when. The protagonist in this case, the victim who survived, RB, was a minor who in Johnson County Juvenile Court had been released pending from custody pending entry into a rehab facility on April 8th. So the last night of his ostensible liberty, he decides he wants to get high one more time. And so he enlists his older brother, who's actually an adult, MB, to help him get some marijuana. Now, they don't have any intent to pay for this marijuana,
Okay,
although...
and I'll just interrupt you just for my own. In the last exchange I had with defense counsel, I had thought that defendant was the one who was purportedly selling the marijuana.
Correct.
And okay, so I was correct about that.
Yes.
And okay.
Yes, Justice Steele, you're correct on that. They search for a plug. That's the word specifically they use. They're looking for a plug, someone who sells drugs, someone who can get them drugs. And through a friend that RB has, he gets the number of the defendant. And there's some messages exchanged between them, and there's a deal struck between them for $500. The brothers will give $500 in exchange for a QP, a quarter pound or 4 ounces of marijuana for them. So it's the defendant who's the one doing the distributing in this. It's not RB or MB. To effectuate this robbery, they just intend to snatch and grab, according to RB, and just sort of run away. But RB takes with him a steak knife from his mom's kitchen for protection. They proceed to a library in Johnson County, Kansas. They're waiting in the parking lot. The defendant arrives later, and RB goes inside of the defendant's vehicle. The defendant shows him 2 quart-size or 2-gallon-size bags full of marijuana, and then he hands RB a nugget of what he says is marijuana. He says it looked right, it smelled right, it seemed to him like it was marijuana from the trial transcript. And as counsel noted, defense counsel on cross-examination did an effective job, I concede, of trying to sow doubt in the jury's mind that this was not in fact marijuana. Well, the the drug deal goes wrong, as drug deals so often do, and the defendant is the one that snatches the money from RB. The brother sees that this has happened. He goes to the defendant and begins hitting him with his fists. At that point, the defendant produces a firearm, perhaps 2, and then shoots MB repeatedly, killing him from that. The defendant then drives off and then comes back trying to kill him. That was, I believe, RB's testimony. It's also borne out on the surveillance footage as well, that his vehicle returns repeatedly to the scene before police arrive. RB is the one that calls 911, and he cooperates with police, telling them, this is what happened. We were trying to rob someone. My brother died. So he does not paint himself in any good light. RB's testimony, he gives the good, the bad, and the ugly in this whole situation. Police are able to connect the defendant. They're able to identify him with the phone number, with the some blood on the knife that RB had. He was able to get the defendant at a certain point when he sees that his brother's in trouble. And there's blood on the knife, and the DNA report essentially says that this is the defendant. So all of that is sort of summary of what happened, how this came to be.
Where was Was the marijuana ever seized by law enforcement?
No, Justice Rosen, the marijuana was never seized. The defendant drove away on the night in question. His vehicle was found in Kansas City, Kansas, I believe. It was burned out. There was really no evidence of drugs that they could or did recover from that, although there was evidence of ownership. So the state's argument then and now is that, you know, any evidence was gotten rid of, it was destroyed. And I think there was a span of 2 days and some hours from the time when MB was murdered to the time when the defendant was identified and presented himself to police. He did turn himself in upon request. So there was no chemical testing. There was no drug testing of any marijuana. There was no factual question as to whether or not this was Delta 9, CBD, or something else. The evidence which the state relies upon to support distribution of marijuana is the impressions of RB, that it seemed right to him. The deal was arranged for marijuana. That was the intent of the parties in coming to this location. And it was at night. I will state that as well. There's no reason for them to be here except to effectuate a drug deal. The question then is to whether or not this occurs within the res gestae of the crime and whether or not there is a causal connection between the two. So res gestae of the crime being in, it's in the same sort of so associate, it's before, during, or after the crime, and so related in time, place, and relationship as to form part of the occurrence. And this indeed is one of those situations where the drug deal goes wrong, the intent of the parties changes at some point, and someone dies in the course of it. I think I'll disagree slightly with counsel as to the intentions of the defendant when he came there. I think it's a fair reading of the evidence that he had every reason to believe that this was a legitimate drug deal, perhaps, and he changed his mind that he wanted to do a fair drug deal when he perhaps sees RB, who is a juvenile. The defendant is an adult, obviously. He probably thinks that this is an easy mark. So I think that probably it's a fair reading of the evidence that the defendant, if RB is to believe that, you know, the money snatched from him, that intent sort of developed during the course of the.
Am I understanding the facts correctly, that the evidence supports the notion that whatever the intent of the defendant was, there was one point at which he, I'll say, proffered a sample to the victims?
Yes.
So that was a physical transfer of the substance, which was testified to be marijuana.
Yes, there was that physical nugget that Roman Babic testified to that he believed was marijuana, but yes, he also conceded he had questions.
So even if we credited the defendant's argument that the intent of the defendant all along was to commit a robbery and essentially take back all the marijuana, there was, at a minimum, there was that physical transfer of the product, even if it was a bait, let's say.
Yes, that is literally true, based on the testimony of Roman Babic, of RB. I think I'll rest on the brief as it relates to most of the issues, but I do think that issue 5 is an interesting, it presents an interesting question before the court as to whether or not RB's testimony was so extraordinary as to whether or not it could even be believed, based on this court's now 50-year-old holding in State v. Matlock. I would ask this opportunity, I ask the court to take the opportunity to overrule the Matlock case. It has in the past described it as an anomaly. Essentially, the facts of Matlock, a rape conviction was overturned in the assessment, and a 4-3 decision was that the victim was so inconsistent, so unbelievable that no rational jury could have convicted based on that testimony. And that, as cited in the brief, that opinion does not appear to be based on Kansas case law. It appears to be based on Missouri, Oklahoma, other case law. And it's also inconsistent with this court's holdings that it is not a fact-finding court. That is up to the jury to decide credibility, to weigh testimony, to decide what in fact is believable and what's not. So, and it also has some outdated notions in it as well. Matlock specifically seems to focus on sexual crimes that for some reason victims in those cases are less credible than victims in other cases. So it's in contradiction. I think the court, you can make the argument that it's already overruled implicitly by the fact this court doesn't review evidence, that even the most serious offenses can be sustained by circumstantial evidence. So, but it still is somehow just out there. That concludes my prepared presentation. If there are any questions from the court, any clarifications I can make. Thank you.
Thank you.
May it please the court. If I could just touch on, I suppose, quickly what you were getting at, Justice Steele. There was a moment where, and I think I was just confused about, were you thinking that my client had testified in his own defense or something? But no, the only evidence of sort of that I guess we could glean his intent from would have been the text messages that were that RB gave up voluntarily of his phone between him and my client. The other part would then be that brief moment where he,
Yeah,
where he hands them and says, "Here's what
that was in our last exchange, kind of
That's
where
where
I was headed with,
Okay,
in terms of what is the evidence of an intent to distribute.
okay.
And my question essentially is, why wasn't it enough that there was evidence that your client offered to sell, even if it was a lie, he had offered to sell,
Right.
and then they were in the car and he proffers him a sample and he makes a physical transfer? Why isn't that enough?
Because I think intent means to do a specific purpose.
But even if you were intending to rob, I mean, he also intended to hand, I mean, as part of the robbery.
Robbery, I understand
But he's
that.
still distributing,
As,
right?
as part of the ruse of my
Yeah.
robbery, and I understand what you're getting at.
Isn't that enough?
Well, here's the thing though. Under Mora, you have to look at what distribution means.
But I don't understand yet how Mora relates to this case.
Because you can't, I can't distribute to myself, right?
But he's not.
So
He's, even if it's a
he's
ruse.
distributing it to, okay, let's just say that he's distributing it. Under Mora, that opinion holds that where two people are acquiring marijuana to share it amongst themselves, that's not distribution. They testified that that's what they were going to do with the.
That would have to do with the
Right.
alleged distribution between the two victims, not between the purported seller and the buyer. Mora doesn't talk anything about that. It talks about sharing between friends when they purchase together.
After the distribution is completed, is that? Okay, well then I've misunderstood more.
Okay.
Unless the court has any additional questions, I'll waive the remaining. Thank you.
Thank you. Thank you to both attorneys for their arguments in this matter. The court will take this under advisement. We are now in recess until 10:30.
All right.